The hearing will come to order. To begin, the representative of the minority, one of the members of the minority, is on the way up. But as he gets here, I am going to ask unanimous consent that our colleague from the Foreign Affairs Committee, a major author of the bill, the gentleman from Florida, Ms. Ross-Leighton, be given by unanimous consent the right to participate as a member of the hearing. Is there any objection? There being none, the gentlewoman from Florida will participate as if she had been a member. This is a very important hearing. It's particularly relevant for us to be doing this because I think it's fair to say that this whole effort has been a result of congressional involvement. We are often told that we should stay out of foreign policy, that it is, in fact, up to the executive, and we may from time to time send them notes expressing our opinion, but we should not anticipate any significant weight being given to those expressions of opinion. This is an example of why it is a mistake to pay attention to that argument. If it had not been for work that began in this particular committee under the chairmanship of our former member from Ohio, Jim Leach, things would not be nearly as far along as they are. Now, they're not where they should be in the opinion of many, but they are somewhere, and there would not have been had there not been this intervention. I was grateful to one of the advocates and my constituent, Mr. Arbeiter, who mentioned in his statement that this began, I think it was about 10 years ago, with hearings that Mr. Leach convened, and we will continue that. So this is a subject of particular interest to this Congress and to this committee. I cannot think of an issue, to touch briefly on the substance, that is more important than doing justice to the victims of the greatest crime in recent times, perhaps in all of history. And people should not be surprised when that insistence that justice be done as fully as possible motivates members of this body to the extent that it does and that it will. And there are obviously other considerations that come into play, but even considerations that have some impact in the normal course of events, in my judgment, shrink in their importance when measured against the need to provide justice to victims of the Holocaust. Obviously, the great majority of victims are beyond any recompense. They're beyond anything we can do. And that is a terrible and tragic fact. But it makes us all the more eager to make sure that those who are still here, those who did survive, that we do everything possible to them, that we not compound in even the most minor of ways the past tragedy by letting remain undone that which should be done. Now, I'm going to stop now because there was a great deal of interest in this, and a number of my colleagues want to make statements. We have a number of witnesses. I will ask people to be cognizant of the time, and I will begin with the gentlewoman from New York, the chairman of the Financial Institutions Subcommittee, Ms. Maloney.
Thank you, Mr. Chairman, and I'd like to be associated with your remarks. This is a very complicated and highly sensitive issue, and I hope that today's hearings will shed more light on how we can resolve the problems that still exist. The International Commission on Holocaust-era Insurance Claims was established in 1998 to give Holocaust victims and survivors a way to settle their insurance claims. The agreement did not charge claimants to file a claim and included relaxed standards of proof, recognizing that for many people, papers and documents were understandably destroyed by the Nazis. Over the years, I have participated in a number of oversight and Government Reform Committee hearings on this issue and have learned about the successes and the shortcomings of this program. It's become clear that it was a positive step towards addressing Holocaust insurance restitution, but that much, much more is needed. Over a period of about 9 years, over $306 million was paid out to roughly 48,000 of about 90,000 claimants. 34,000 of those received $1,000 humanitarian awards. Though I firmly believe that intentions were good with this program, it has not achieved the goal of processing claims quickly and fairly for the survivors, the very people who are now running out of time. I am co-sponsor of 1746 because I believe transparency, justice are our primary obligation and which we should give to the survivors. When something doesn't function properly, we need to find a better solution. In this case, this bill offers a better solution. The bill would require insurers to disclose Holocaust-era policies, and without an exhaustive list of policyholders, we will not be able to reach everyone affected. The bill also establishes a federal cause of action, allowing individuals to pursue claims in U.S. courts. Survivors must not be denied the sole class of people who they should have their day in court, and they should not be denied their ability to go into court. And too much has been taken away from them. This must not be another thing that is taken away from them. And I understand that there is some opposition. I look forward to hearing the testimony, but in the end, I believe strongly that we must not let obstacles get in the way of doing the right thing and helping the Holocaust survivors. I yield back the balance of my time.
The gentlewoman from Florida.
Thank you so much, Mr. Chairman. First of all, thank you for your kindness in allowing me to participate in the committee's hearing today. Certainly the Holocaust stands as one of the darkest chapters in human history. Over half a century has passed since the world witnessed the atrocities committed by Hitler's regime, yet many Holocaust-related issues remain unresolved. One of these is the continued failure of insurance companies to pay Holocaust survivors or families of Holocaust victims for policies they purchased before or during World War II. These insurance companies have for over 60 years refused to provide compensation under the insurance policies to Holocaust survivors or families of Holocaust victims. These companies argued that Holocaust survivors and their families do not have the documentation such as a death certificate and insurance records. Concentration camps in which many of these Holocaust victims perished did not issue death certificates, and all assets and documents were confiscated from the Jews during that time by the Nazis. For years, I have worked on the issues related to Holocaust-era compensation, and to address the issue of insurance policies specifically, my colleague Robert Wexler and I introduced H.R. 1746 in March of last year. Among other provisions, the bill requires insurance companies that do business in the United States to disclose the names of Holocaust-era insurance policy holders. Furthermore, the measure will allow Holocaust survivors or their heirs to sue the insurance companies in U.S. courts. People often ask Mr. Wexler and I why we introduced this bill and why we feel so strongly about this issue. Well, let me answer by reading one of the many letters that I received from Holocaust survivors. And this one is from Elizabeth Lefkowitz of Florida. Dear Congresswoman Ross-Layton, my name is Elizabeth Unger Lefkowitz, and I am a U.S. citizen and a Florida resident. I was sent to the Auschwitz concentration camp in 1944 when I was 20 years old. During the Holocaust, I lost both of my parents, my grandparents, my two sisters, and a 2-year-old nephew. After the war, I found a document that was hidden by my father, Ignaz Unger. This document contained his life insurance policy for 25,000 gold dollars. In 1945, when I presented the insurance claim to the insurance company, they requested a death certificate as the prerequisite to pay the claim. Without the death certificate, they said the policy was invalid. A few years ago, the International Commission on Holocaust-era Insurance Claims revived our hope for justice with the insurance companies, and I filed a claim number 77452, reference Ignaz Unger Life Insurance. Unfortunately, this effort produced no results. I'm very glad that the Holocaust Claims Insurance Accountability Act, H.R. 1746, legislation has been introduced in Congress, and if passed, the insurance companies doing business in the U.S. that profited from the Holocaust will be held accountable for their actions. So, Mr. Chairman, it is because of Ms. Lefkowitz and countless others who share her history and her tragedy, her circumstances, that Mr. Wexler and I introduced our bill. Unfortunately, today, obviously, we cannot bring back those who perished in the Holocaust, nor can we erase the pain and suffering from the memories of those who suffered these atrocities. However, we can work to bring about long-awaited justice to Holocaust survivors and their families. Because the number of Holocaust survivors who are alive decreases drastically every year, it is critical that Congress move expeditiously to pass H.R. 1746 and offer a level of closure to those who suffered immensely under Hitler's regime and then were shamelessly mistreated for decades by the insurance companies that sought unjust enrichment at the expense of Holocaust victims. Thank you again, Mr. Chairman, for the opportunity to participate in the hearing.
The gentlewoman is welcome, and you never know when I want to show up at Foreign Affairs and make a speech, so I'm sure you'll remember that. The gentleman from New York, Mr. Ackerman, who has been a strong advocate of justice in this area, is now recognized.
Thank you very much. First, let me thank you, Mr. Chairman, for holding this, what I consider essential hearing before our committee. And of course, you're always welcome at our International Relations Committee as well. Special thanks to Mrs. Ross-Leitonen and Mr. Wexler for being the authors and initiators of this important piece of legislation that would finally bring some justice to so many people for whom justice has been denied. The issues surrounding the question of Holocaust-era insurance restitution are both immensely sensitive and highly complex. More examination yields less certainty, more questions, finer distinctions, and unabating concern that not only has justice not been done, but that it may never be done. While the principle of restitution is stark and clear and definitive, there are significant differences in the policies and behavior of the relevant European insurance companies and among the countries in which they are based. There are differences based on the type of assets that were systematically stripped from Holocaust victims. There are differences in the scope of records, in the history of different firms, in the limits of privacy laws, and there are differences among the survivors, plaintiffs, and heirs. And there are questions. There are questions about the scope of assets deserving restitution. There are questions about the transparency and the efficacy of the I-check process. There are foreign policy questions. There are constitutional questions about the proper role for America's foreign policy interests in the context of private civil litigation. There are public policy questions about the role of the states and the federal government when it comes to insurance, moral questions about the rights of communities to speak for individuals, and philosophical questions about what justice means in so singular a catastrophe. In this case, Mr. Chairman, the more that I learn, the less I seem to know. Accordingly, Mr. Chairman, I want to suggest that this hearing should be the first of a series. While we must recognize that many survivors are entering their last years, I believe the issue is too important and too complex for us to fail short in our due diligence. We need to act both quickly and correctly. We need to get this right. Mr. Chairman, thank you again for bringing the matter before the committee, and I yield back the balance of my time.
Gentleman from Delaware.
Thank you, Mr. Chairman. I appreciate the opportunity of being here. I appreciate the opportunity of learning something about the issue. This is very complex for those of us who are coming in from the scratch on this, and I have no particular opinion as to the legislation at this point. But I do think the issue is of huge importance, and I agree with Ileana and others of the need to look at this to make a determination of what, if anything, should be done or we should be doing from a legislative point of view to try to help, particularly with the survivors of the Holocaust. On the other hand, the complications of how to do that also presents some interesting questions, and that's why it's very hard to say that this legislation is absolutely the right course of action. I believe the hearing we're having today, which unfortunately I won't be able to take full part in because of other scheduling issues, is of vital significance in terms of developing exactly what our course of action should be. I appreciate all the witnesses who are here today and all those who are participating, and I think we have a responsibility to try to learn all that we can in making a fair and good evaluation of where we are and what we should be doing. I realize that even among the witnesses there are some differences, and for that reason we have a responsibility, I think, to try to sort this out and make sure we're going in the correct direction to try to alleviate a problem which we all agree is there. So I appreciate, Mr. Chairman, the opportunity of participating and of learning and hopefully helping come up with a final resolution which will be in the best interest, particularly to the survivors of the Holocaust. I yield back the balance of my time.
The gentleman from Florida, Mr. Mahoney.
Thank you, Mr. Chairman. I appreciate you holding this important hearing today. I would also like to thank my colleagues from Florida, Mr. Wexler and Ileana Ross-Lathan, for their leadership on this important issue.
Is it a problem in your district?
Mr. Chairman, I believe this hearing is the utmost importance because we as a society owe survivors of the Holocaust the opportunity to have their voices heard. There is no greater way to honor the victims of the Holocaust than to let their stories be told. This issue was first brought to my attention by one of my constituents, Mr. Alex Moskovic. Mr. Moskovic, who lives today in Hobe Sound, Florida, and is a constituent, is a Holocaust survivor from Sobran, Slovakia. In 1944, Mr. Moskovic, his parents, Joseph and Gidel Moskovitz, and two brothers were deported to the Auschwitz-Birkenau concentration camp. Mr. Moskovic was the only one of 41 family members to survive the Holocaust, enduring a torturous march through freezing weather, nearly 2 weeks on a cramped train where thousands died of hunger and the horrors of Auschwitz. Upon his return to Sobransk after the war, he found that his family's house had been destroyed. In 1947, Mr. Moskovic came to the United States, where he established a successful career as an editor for ABC Sports. In fact, Mr. Moskovic was awarded numerous Emmys for his 30-year career. After moving to Florida, Mr. Moskovic volunteered to work on the advisory committee of the Ruth Rales Jewish Family Services Board in Boca Raton, a nonprofit organization that provides members of the Palm Beach County community with counseling and an educational program. In addition, he's a member of the Board of Directors and Executive Committee of the Holocaust Survivors Foundation, where he has worked tirelessly on this issue. I wanted to spend a few moments today talking about Mr. Moskovic's story because I believe it's important for the members of this committee to hear the stories of those fighting for restitution, whether it be through the International Commission on Holocaust-era insurance claims or other agreements. Mr. Chairman, I hope that as a result of today's hearings, we have a better understanding of how the ICH-EIC process worked, the promises that were made by the insurance industry, the agreements reached by the U.S. government. I'm also interested in hearing what each witness thinks the impact of H.R. 1746, the Holocaust Insurance Accountability Act, will be on the process moving forward. In the final analysis, gentlemen, right is right. In this case, this body needs to make sure that these claims are paid. To deny these benefits to Holocaust survivors on the basis of politics or administrative snafus only serves to trivialize the Holocaust itself. These unpaid premiums do not belong to the insurance companies. They belong to the survivors. Again, thank you, Mr. Chairman, and I yield back the balance of my time.
The gentleman from Connecticut wishes to make a statement.
It'll be a short one, just to say that I agree and want to align myself with all the speakers, and particularly Ileana Ross-Lathan, and to say that as a Peace Corps volunteer, we had a lot of time to read, and I read all of Leon Uris's books. You can't read Exodus, Mila 18, particularly Mila 18, Armageddon, without realizing there is nothing to compare to the Holocaust. There is nothing. Nothing comes to the level of the Holocaust, this premeditated factory system of annihilating people. And I just really believe this is one of many hearings we've had so far in Congress. I really hope we're able to push a little harder and to see some action overseas in particular. Thank you.
The gentleman from Florida, Mr. Kine.
Thank you, Mr. Chairman. Mr. Chairman, I come to this hearing with mixed feelings. On the one hand, I'm profoundly disappointed that it has taken so long for survivors to get an inkling of hope that their claims will be settled. And although there's been a lot of representations over the years and some action, we stand here today 63 years after the end of World War II. And there are families and survivors that have never had any type of compensation for an insurance policy that was purchased during or prior to World War II. I appreciate the fact that the chairman and Congresswoman Eleanor Slaton and Congressman Wexler have brought this forward. I personally have been involved in Florida in Holocaust education and awareness and working with a lot of people in our community who have had great needs because of their economic situation. The survivors who are here today appreciate your coming forward and bringing your stories forward, but this is not just about stories. This is about what's right and what's moral. And as far as I'm concerned, we don't have to have long hearings. We don't have to have multiple hearings to get this issue resolved. This has been discussed, it's been debated, it's been analyzed, and with the number of people that are remaining today and the age of many of the survivors, the time is now to finish and do the right thing. Thank you very much, Mr. Chairman.
The gentleman from Georgia, Mr. Scott.
Thank you, Mr. Chairman. First, I want to thank you, Mr. Chairman, for holding this hearing on this long overdue issue. It is very important that we continue to address this decades-long movement for fair and just equality for survivors of the Holocaust as it relates to the thousands of still uncompensated insurance policy holders. And even as the International Commission on Holocaust-era Insurance Claims was set up to address various issues involved and settle outstanding Holocaust-era policies, there are still today delays in participation of these insurance companies. Companies fail to provide the comprehensive list of the policyholders' names, and as we know, these individuals' names are essential, as Holocaust survivors and heirs often recall that their families held these policies. However, they do not know the name of the companies that issued the specific policies. These insurance issues facing Holocaust victims and their survivors are extremely complex, and efforts to provide restitution are certainly challenging at best. However, it is very, very important that we look into other ways to help speed up this process and maybe curb some of the frustrations being experienced by all involved. And that's why, Mr. Chairman, I'm very proud to support H.R. 1746, which would do some essential and very important things. Number one, it would create a publicly available registry of insurance policies issued between January 30th, 1933 and December 31st, 1945 to persons who were domiciled in an area controlled by Nazi Germany, and require insurers to file information on these policies with the Secretary of Commerce within 90 days of the bill's enactment. Very, very important. And secondly, this bill will create a federal civil cause of action for any claim arising out of such a policy. This is a very, very important piece of legislation. It moves to correct one of the great omissions and one of the greatest sins of mankind's humanity, of inhumanity against their fellow mankind. Thank you, Mr. Chairman.
Gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman. And I associate myself with the remarks of the chair. I have had the opportunity to traveled to Israel and I visited the Holocaust Museum. And I assure anyone who questions why we are so concerned that if you have an opportunity to just visit one of the museums, we also have one in Houston, Texas, you will understand. Tears literally welled in my eyes as I saw the pictorial representations of the horrors and the atrocities that were committed. We are truly embracing a circumstance where we cannot do enough. We really cannot. However, whenever you cannot do enough, you do have a duty to do all that you can. We must do all that we can to bring justice to the victims of the most horrific atrocity perpetrated upon humankind. I yield back the balance of my time.
The gentleman from Florida, Mr. Wexler, a sponsor of the bill and a major mover in having this hearing and in trying to get action.
Thank you very much, Mr. Chairman. I am deeply grateful to you for your seriousness of purpose in allowing us to have this hearing. I'm also deeply grateful to my colleague and friend from Florida, Mrs. Ross Langtonen, for being a champion. The two of us have worked very, very hard in bringing this issue forth, and there is opposition. And what I would like to do, Mr. Chairman, is talk about the specific facts relating to this bill, what the bill actually does, what the opposition is, and why, in my view, that opposition is not meritorious. First of all, this bill essentially does two things. It mandates that insurance companies who do business in the United States publicly disclose all Holocaust-era insurance policies. Why that should be debatable, why there should be controversy about whether or not insurance companies who have profited from the Holocaust should disclose their insurance policies in the United States 60-some-odd years afterwards, to me, is not debatable. It should be disclosed, period. There should be no legitimate debate. The second part of the bill is that those people who claim to have insurance policies are given an opportunity to go into federal court and prove their claim. There's a couple of misnomers here. If we pass this bill today, Mr. Chairman, not a single Holocaust survivor would receive a penny. Not a single one. Because they'd all have to go into federal court and prove their claim. Do they have a lower standard that they have to prove in federal court than anybody else who walked into federal court? No. They'd have to prove the same insurance-related evidentiary matters as everybody else. So what's the issue? The issue is this, is that previously we entered the United States of America into an I-check process. And that I-check process, to sum it up, has divvied out, according to Secretary Eagleberger, who is, in fairness, an opponent of this legislation, $306 million to the survivors of the Holocaust. If you add in the amounts of money that were given to the Claims Conference and other related organizations, $450 million has been distributed through that process. Now, is that a fair amount? That should be the question everyone's asking. Well, if you use the amount of money estimated by the proponents of the bill, the assets available, in other words, the amount of the insurance policies that these companies hold, are probably about $17 billion. But even if you use the estimate of the opponents of the bill, if you use the estimate of Ambassador Kennedy, who I have enormous respect for, he's a terrific man, the estimate is roughly $3 billion. So the opponents of the bill essentially are saying that even though $3 billion is rightfully owed to survivors of the Holocaust, $450 million has been paid, and that's it, 15%. In other words, what the administration is saying, what the opponents of the bill is saying, is that 85% of the value of the insurance policies held by survivors during the Holocaust should remain with the insurance companies, period. And what they will argue is that legal peace was made. and that it's not fair, it's not equitable today to undo that legal peace. Well, there's a big problem with the argument of legal peace. How is it that insurance companies who have not fully disclosed their policy owners can take advantage of the agreement that was made by not having to pay out that which is rightfully owed, and those that are rightfully owed are penalized by the agreement? This can't possibly be an equitable conclusion. So the question isn't whether or not we are abrogating the word of the United States government. The question is, there are insurance companies who hold billions of dollars of assets rightfully held by the survivors of the Holocaust. And is this Congress, in the last moments of these survivors' life, going to give them an opportunity to use our federal judicial system to gain some measure of justice? If this bill does not pass, game over. Game over. Insurance companies keep 85% of the assets, even using the insurance company numbers, the administration numbers. They keep 85% of the assets that are rightfully owed by the survivors of the Holocaust, and they are not required to disclose those policy owners that rightfully have a right to know who they are. Thank you, Mr. Chairman.
There will be no demonstrations, none, zero. We will now begin the hearing, and I am pleased to welcome the representative of the Department of State. I'm especially pleased to welcome the representative of the Department of State today because I won't be able to do that tomorrow when we have a very important hearing on the signing statement issued by the President that would undercut the effect of our bill to strengthen the divestment from Sudan, and the State Department has refused to show up. But we are glad to have Mr. Kennedy. We'll take what we can get from this administration, and we won't ask you to defend that. We will ask you instead to discuss this position. So, Ambassador J. Christian Kennedy, who's a Special Envoy for Holocaust Issues at the Department of State, you are now recognized.
Thank you very much, Mr. Chairman, and thank you to you and your colleagues for the invitation to be here today. Thank you for holding this important hearing about issues concerning my office's main constituency, who are Holocaust survivors. We all agree that those who spent the Nazi era in concentration camps and ghettos or in hiding deserve not only our sympathy and moral support, but also a measure of justice in their lifetimes. Our office therefore supports the continuing general effort to obtain compensation for their suffering and restitution or compensation for their material losses. Your hearing today deals with insurance purchased by Holocaust victims and the International Commission on Holocaust-Era Insurance Claims, known as ICHEC. Let me say that the State Department believes ICHEC was very successful in dealing with the most difficult life insurance claims arising from the Holocaust, cases where the claimants had no documentation or only the scantiest of records. Earlier claims payments programs starting in 1953 had already dealt with other life insurance claims. ICHEC created a process that included archives, appeals, audits, payments to individuals totaling more than $300 million and nearly $200 million to humanitarian programs administered by the Claims Conference. It's a signal achievement, and I know that you will hear much more detail from the following panel. Since 1969, State Department negotiations with governments, companies, and non-governmental organizations have made over $8 billion in new money available to Holocaust survivors and other victims of the Nazis. Because negotiation and conversation have been so successful in getting Holocaust victims and victims' heirs a measure of compensation, the administration opposes H.R. 1746. Which would make litigation the main vehicle for claiming unpaid life insurance proceeds. Litigation always bears great uncertainty for the litigants, and it takes time. Negotiation is faster, especially with well-meaning partners. Holocaust reparations are part of our very strong relationship, bilateral relationship with Germany, for example. Thanks to ongoing negotiations and the strength of this relationship, Germany has made available 350 million euros in new pensions and one-time payments to survivors since March 2007. March 2007 was the date when iCheck closed its doors after completing successfully, we believe, its very important task of processing the most difficult life insurance claims arising from the Holocaust. iCheck succeeded because of voluntary cooperation between insurers, governments, American state insurance regulators, and Holocaust survivors organizations. It did not charge claimants for its work, and nearly 48,000 people received payments. iCheck compiled a list of 519,000 names of people likely caught up in the Holocaust who also probably had life insurance policies. This database was the result of careful research and cross-checking with Israel's Yad Vashem Museum. The completeness of this database was driven home for me very recently. We received a few days ago a Gestapo document that included 2 names of Holocaust victims who were listed as owning life insurance policies in 1942. A quick check with iCheck's 519,000 name list showed that the names of both people were on that list. Returning to the broader issue, iCheck undertook research across company archives and even international boundaries to complete its database. Its research also studied insurance markets extensively, for example, the number of policies per capita in given countries. Most important, perhaps, is that dialogue and negotiation allowed iCheck to establish relaxed standards of proof in order to pay claims. And insurance companies cooperating in the iCheck process have agreed to continue using relaxed standards of proof to process new claims that might appear even after the extensive outreach that iCheck did. The administration is concerned that because H.R. 1746 favors an adversarial relationship of litigants over negotiation, the bill would undermine the many positive working relationships we have built over the years and discourage countries that haven't met their obligations to survivors. Lastly, let me touch on ongoing business. Germany has paid Holocaust reparations totaling nearly $100 billion in current value, but we still have many pending issues there involving elderly survivors. My office is involved in conversations and negotiations with other countries too, especially the new democracies in Europe, where much remains to be done. In negotiating the bilateral executive agreements that supported the creation of iCheck, we promised legal peace if participating companies were sued in U.S. courts about matters relating to the Holocaust. This legal peace does not prevent U.S. citizens from bringing suit, but it does obligate the government to seek dismissals. Our partners expect us to uphold our word and see H.R. 1746 as a grave threat to legal peace. If we cannot keep our word given in negotiations that have borne so many positive results, future negotiations will be much more difficult. The perceived inability to keep our word would undermine our capacity to continue helping survivors of the Holocaust and the heirs of victims. Chairman Frank, members of the committee, thank you very much for your invitation to be here today. I will be happy to answer your questions.
We'll hear from the Assistant Archivist for Record Services of the National Archives and Records Administration, Dr. Michael Kurtz, please.
Thank you, Mr. Chairman. I'm honored to be here today, and thank you for the invitation to testify. For the record, I'd like to note that the holdings of the National Archives, we have tens of millions of pages relating to all aspects of the Holocaust, and we have worked assiduously over many decades to make these records available. I was honored to serve as the first chair of the Interagency Working Group on Nazi War Crimes and worked very closely with Congresswoman Maloney, who was the legislative leader of this effort. And our concerns with the bill are of a practical nature, as the National Archives would be responsible for the creating and servicing of the registry, and we have also concerns about the funding. So we tackle these issues from a practical point of view and ask the committee's consideration of these concerns. First, the size and scope of the registry is unclear, and there is no firm number for the size of the registry. We estimate that there are potentially millions of names of individuals who could file claims and submitting claims in a variety of different formats and styles and so forth. So it's been very difficult to estimate exactly what resources would be required. Our information technology experts roughly estimate the cost to be at about $28 million. One of the major concerns that we have is the National Archives is a small agency, and we are fully taxed at this point trying to implement an electronic records archives for the first time. So almost our entire IT staff is devoted to this, and so we would need a stable and secure source of funding. We estimate it would cost about $28 million to develop and maintain the registry over the life of the legislation. And our concern with the funding is we're unclear from the bill as drafted if the penalty fees charged against non-compliant insurance companies would be the main or sole source of the funding for the registry. If that's the case, if insurance companies do comply with the law, we would have responsibility for web access to potentially huge names, a name registry, but we would not receive any direct monies to establish and maintain the registry. So we really strongly state the need for a stable, appropriated source of funding that would enable us to get the infrastructure created necessary to properly create and service the registry, and to hire the expertise, both information technology and archival expertise. There are a number of issues related to privacy and information security and things of that matter that we really would need experts to work with us on. So this would be a new and separate line of business for the National Archives, and we would need the support of Congress with a clear, stable source of funding to be able to do this. And Mr. Chairman, thank you again for the opportunity to testify on this bill.
Thank you. Let me begin my questioning. Ambassador Kennedy, I understand the State Department's concern with bilateral relations with Germany. Indeed, the German ambassador came in to see me. Does anyone think that the outcome of congressional deliberations on this bill will have any significant effect on overall American-German relations? I must tell you, I'm of the opinion that the nature of the ties that bind us, the issues that might arise, really are of such magnitude that it's hard for me to see that the fate of this bill, one way or the other, would have any significant effect on our relations. Is there a serious concern about American-German relations if this bill passes?
Thank you for that very important question, Mr. Chairman. Let me answer in two parts, if I may, one personal and one broader. I have been very surprised at the depth of feeling from my German interlocutors on the subject of this bill, both in the private sector as well as the official sector. This is something which they take with great umbrage. In the second area, or more broadly, I think it's hard to envision a change in a relationship that has been collaborative, that has been based on negotiation, that has produced substantial results. I don't claim they're enough, that they're sufficient, but substantial results. It's hard to see how that would not have a negative impact on the relationship. In the broadest sense—
What kind of negative impact? I mean, what would you
as I said in my statement, sir, we still have a number of issues to resolve involving Holocaust survivors. And that's of course, the area that I worry about the most.
Well, would you see any— you are testifying on behalf of the Department of State.
I'm sorry?
Would there be any— there were suggestions from some that there might be a spillover into broader issues, because the American-German relationship is a very important one in terms of Europe, NATO, the economy. Do you see any broader negative implications?
Well, I think that would be speculative at this point. I know that in the area of Holocaust reparations, I think I can say clearly that there might very well be some very negative repercussions.
You mean they might stop cooperating in some areas where they're not cooperating?
Well, the companies—
I'd like to be kind of specific.
The companies certainly would not want to, I think, deal with an issue in the courts and also deal with it in negotiation. They would have to choose a venue.
So there are ongoing negotiations that would be broken off, you think, or might be?
I think there is that risk, yes, sir.
And Dr. Kurtz, your issue went to two, as I read. One was the absence of an end date in maintenance of the records, and then also the money. If we could meet, just one question. You mentioned $28 million. Is that an annual cost or a total cost?
That would be a total cost.
Total cost, $28 million.
$22 million for the creation and servicing of the registry, and about $2 or $3 million a year for ongoing maintenance.
All right. So we're not talking about huge sums. That is, it would be within the capacity of this Congress if we were to pass the bill to appropriate $28 million would take care of this. If we were, in fact, to accompany passage of the bill in some form with the $28 million and give you enough time to hire, would that then be disruptive of your operations?
No, I don't think it would be disruptive.
Thank you. Gentlewoman from Florida.
Thank you so much, Mr. Chairman. Thank you, Mr. Ambassador. I wanted to ask you a few questions about the I-check process and proper compensation for the victims and their descendants. I-check has been criticized for failing to review hundreds of thousands of relevant files. For example, I-check's final report of external research indicates that when looking at the Central Property Office files of Slovakia, more than 700 boxes or records dealing with the Aryanization of Jewish firms in Slovakia were found, over 700 boxes or records. And these files contain information about the assets of the firms or their Jewish owners. However, the researchers searched only what they call, quote, a small amount, end quote, of those 700 boxes, which provided information about 18 policies. Would it be accurate to say to either of our witnesses, actually, that there were many files that I-check did not examine containing information about Holocaust-era insurance policies, and shouldn't the beneficiaries of these policies not have a right to be compensated for their insurance policies?
Thank you very much, Congresswoman. I think that the point I'd like to focus on in replying is that if insurance policy documents come to light, and there will be a few, the members of the I-check participating companies have all agreed to continue to use the relaxed standards of proof that characterize the I-check process to process those claims. So while I-check has closed its doors, the companies have said that they will continue to use those standards as they process the claims. And that's what I think is important from our point of view, that the people who have claims can still file them.
Thank you. That in no way answers the question, but on that issue that there will be a few, insurance companies that have participated in the I-check process have agreed, as you say, to continue to consider claims and use the I-check's lower standard of proof. However, there are no oversight mechanisms. There's no way to appeal the decisions of the insurance company, and it seems as though the insurance companies will again be in full control of deciding who will or will not be compensated, as well as determining the amount of that compensation. And considering that I-check was established because the insurance companies failed to act on their own, how would this voluntary process that you talked about, offered by the insurance company, which lacks an appeals mechanism, which lacks oversight, will be at all effective in fairly resolving what you consider a few of these unpaid claims?
Well, in my conversations with people from the insurance associations, They have welcomed the idea of some oversight. I imagine that people here in the United States who have an issue, if their claim is not resolved, would still be able to go to the state insurance commissioners and to other entities that have real expertise in these matters.
Thank you. And just to, Madam Chair, one more question. Thank you for your generosity. Your responses, well, it's often been argued that the court's proof requirements would be a lot more stringent than those used by I-checks, and that it's unlikely that many claims will turn out to be successful. And if that's the case, then I ask myself, why are the insurance companies so worried about litigation? If there is not enough proof, and the case will be quickly dismissed because of lack of evidence, so why not let the survivors have their day in court, have a judge or a jury decide, rather than have an insurance company, again, with no oversight, although they say that they would welcome it. That's a real stretch of the imagination. They have not done so yet. But what would be wrong with having the survivors have their day in court rather than have this insurance company or that insurance company whose interests lie in not paying, in having to pay as few policies as possible? That's how they make their money.
Thank you, Congresswoman. The bilateral executive agreement that we have, for example, with Germany, in no way infringes on the ability of someone to go into court and seek redress right now.
Well, yes, the U.S. federal government cannot forbid U.S. citizens from pursuing legal action against the insurance companies. However, it did commit to filing statements of interest, encouraging dismissals of any legal action against European companies in the U.S., and these statements have prevented lawsuits against European insurance companies brought by Holocaust survivors. And after seeing that only a fraction of the policies have actually been paid out by the insurance companies, and that the I-check process ended without adequately addressing the issue of Holocaust-era insurance policies, shouldn't the U.S. government statement of policy change in order to allow those who have been denied a fair opportunity to recover their insurance policy, to be able to bring their claims to court? I think that would be the fair thing to do. Thank you so much for your time and generosity, Madam Chair.
You're welcome, and you may answer that question.
Thank you very much, Madam Chair. Let me take the two parts of your question separately, if I may. The government negotiated an agreement, and it has been the policy since those agreements were entered into that we would favor negotiation and dialogue to resolve Holocaust-era claims, because they are negotiation has produced results rapidly. I think that's the point I would like to underline there. And secondly, as I said in my testimony, in my written statement, we need to be able to continue to negotiate credibly with countries where there are still many, many issues to be resolved, hopefully in favor of Holocaust survivors and the heirs of the victims. Thank you.
Thank you very much. I will recognize myself for 5 minutes. Let me welcome our witnesses and just raise some very basic questions of you. I do not know all of the details of the establishment of the International Commission on Holocaust-era Insurance. So I'd like to ask you, when this commission was established, or were you specifically given the ability to negotiate this legal peace deal that you negotiated?
Thank you, Madam Chair. The state insurance commissioners here in the United States in the mid and late 90s noticed a serious number of Holocaust-era claims that were not being resolved. And they themselves started to to talk about a mechanism that might deal with this, and this mechanism ultimately led to iCheck. At the same time, the U.S. government, represented very ably by Stuart Eisenstadt, began negotiations with the various countries involved, especially Germany.
I understand that, General.
And
I want to know about the specificity of the authorization. Were you authorized, was the Commission authorized to negotiate legal peace?
Well, the kind of legal peace that is offered, the commitment of the government to seek dismissals, is something that the negotiators felt was inherent in the executive's powers to reach.
This was born out of the negotiations, but there was nothing specific in the establishment of the Commission that gave authority to negotiate and settle on this so-called legal peace. Is that correct? Would you accept that as correctly identifying what power you had or did not have relative to establishing this legal peace agreement?
Well, the agreement covered a number of things, and
did it give you the authority to negotiate legal peace agreement?
Well,
yes
of course,
or no?
I was not present in those negotiations.
So you're not, you don't know whether or not
but
that authority exists?
The authority, I believe, is inherent in the executive's
You think it's implied but not specific, is that right?
I'd be happy to take that question, Madam Chairman.
Do you know if anyone sought the opinion or support of Congress in the negotiation of that legal peace agreement?
Again, I'd like a chance to go back and review the record and get back to you, Madam Chairman.
Is it safe to say that Congress was not involved in that agreement? Do you know of any bill or resolution that was sought or passed in Congress that would support that agreement?
I know of no bill that was sought prior to the education, ma'am. I'm sorry, to the conclusion of the negotiation.
So then, this bill that's before the Congress today would be the first time that we have been engaged on that so-called legal peace agreement. And we were not asked before to give an opinion, to support, to question that agreement that was made, even though the significance of this peace agreement is such that it would deny the opportunity for survivors to even address the issue. So given that it was that important, the Congress of the United States was not engaged on it at all.
Well, Madam Chairman, I don't think that that statement that we deny Americans the right to sue in court is quite accurate. The ability to deny Americans to go into court, the opportunity to go into court, would be something very serious. Americans can go into court. Nothing in the executive agreement
So would you restate just for me?
It simply states that the executive, that the government will seek dismissal on all valid legal grounds.
Okay, thank you. I think that's very clear. And I will now recognize for 5 minutes Ms. Maloney.
Thank you very much, and thank you for your testimony today. Ambassador Kennedy, between 1933 and 38, the Jews of Germany were obligated by law to deliver to the Nazi government declarations specifying all their property and assets. The duty to file such declarations was imposed on all the Jews of Germany, with the clear intention being to use these declarations in order to confiscate all Jewish property and assets in Germany. This documentation is highly detailed, including real estate, money, insurance policies, tangibles, intangible rights, and other assets held by German Jews prior to the Holocaust. However, this information will not be made public until 2018. And my question is, why not? Even the KGB has opened up the files of World War II. We in the United States government, our most secretive agency, the CIA, has opened up the files, the Nazi war crimes bill that Dr. Kurtz and I worked so hard on, to learn and to go forward. Why not? Why are they not opening up these files? This is quite a long, long time. These should be opened. And what are we doing as Americans and as the U.S. government to ensure that Holocaust survivors get access to this very important information? There's absolutely no reason to keep this confidential. These people are entitled to this information, and I'd like to know, what steps have we taken to open up these files, to provide this information and transparency, and what should we do in the future?
Thank you very much for that important question, Congresswoman. There are a number of archival issues that have gotten a lot of serious work over the last few years. We have managed, thanks to the leadership of the United States Holocaust Memorial Museum and my office, to get the International Tracing Service files located in Bad Arolsen transferred electronically to the United States, where we believe survivors will have a friendly environment to work with at the museum. There are archival issues in other countries, such as Hungary, where we have been dealing with our Hungarian colleagues, asking them for specific files as well. My understanding is that the asset declarations, which you mentioned, which were just one more inhumane and criminal tool that the Nazis used in their depredations on Germany's Jewish population, are in the Bundesarchiv in the various German states, and that parties who, under European privacy law, have a right to access can get at those, a specific file for, say, their family. One of the frustrations in dealing with file issues, archival issues for us in Europe is that our legislation is much, much more liberal, and European privacy legislation, I found out in my negotiations on the tracing service, is actually going in the opposite direction, and it's much more restrictive. The lengths of time are, frankly, excessively long, in this American's opinion. I would be happy to raise this issue with my German counterparts and get back to you after my next trip to Germany.
Well, we would appreciate you to raise this issue in writing and to hide behind a privacy protection when citizens, American citizens or citizens of the world, are trying to get information on their insurance policy that could help them. So this, to me, seems like a stonewall, really unresponsive step. You and I know how difficult it is to work through a bureaucracy. So to tell someone, oh, go to Germany and you'll get your file, that is like saying, we're not going to help you at all. And I, for one, think that we should, as a government, request that this information be made available in public, and if they won't do it, then I think our country should do it, along with other like-minded countries that feel strongly about justice. These asset declarations, to hide behind a shield of we're protecting privacy laws, I think is ludicrous and comical. And I, for one, would like to join my colleagues in a congressional letter, or possibly a congressional resolution, that these files should be made public. As I said, our government has opened our files, Argentina's, even the former Soviet Union has opened up the files of the war. And to keep private insurance information hidden until 2018 is just, I think, scandalous, absolutely scandalous. My time has expired. I have a number of other questions. I'll put them in writing. But Dr. Kurz, I do want to thank you for your hard work on the Nazi War Crimes Disclosure Act, the really brilliant work that you did with these archives, and I hope you get the opportunity to work on the asset disclosure declarations and other important archives for our country and the world. Thank you for your testimony.
Thank you very much. The gentleman from New York, Mr. Ackerman.
Thank you, Madam Chair. Thank the panel for the good work that they've done to date, the progress that they've made. You know, I sit here somewhat in disbelief because it's very hard for me to process some of the things that I'm hearing, although I've heard them many times. It seems to me that there's an inherent conflict between life and time. And time always wins. But justice should not fall victim in that contest. In the closing days of World War II, Hitler put on a maddening rush, not to defend Germany because that was all over, but to kill as many Jews as he could, to rev up the action in his murder machinery and put more people in the gas chambers and the furnaces, just to destroy people, to run the clock on them. This is all about running the clock. The insurance companies are in no way part of Hitler's machinery. They are a commercial industry motivated by making a profit. We should not confuse profit with greed. The people who were fortunate enough to be among the very, very few who escaped temporarily from that contest with time
That's yours.
should not fall victim today to our participation in helping with what motivated Hitler. These people are in a very close race. I don't have to tell you what their age is. Some of them are in this audience today. There are others too frail to come. In international relations, it's very, very important that we keep our word. And sometimes we give our word in order to make progress. But there are higher issues and more important values that are really at stake here. What we have done inadvertently, I'm sure, in signing important agreements, even in order to get compliance in issues where there should have been compliance out of a sense of morality rather than negotiation, is put an expiration date on justice. That should not be allowed to stand. Although arrived at honorably, there is no justice in our government going to court against U.S. citizens seeking restitution for horrendous things that were done against them personally, against the people, against humanity. And to be able to prove their day in court without their government standing on the other side of the bar and saying we have to object because we signed a document at one point in time. I am not impressed that Germany has paid out $100 billion or $1 trillion. It's not what's paid, it's what's owed. I think an awful lot are owed to these people, and it has nothing to do with money. It has to do with the dignity that so many were stripped of, the hope to get it restored to which they cling. And are those principles and those values that we have to look, that we have to fight for. How do we go to court and stand up against those who seek restitutions before a court of law to be able to make their case and to say that they should be denied that opportunity because we signed a document? We gave away their rights and put our government in between them and the justice that they seek. I suppose that's the only question that I have.
Thank you very much for your remarks and your question, Congressman. I think it's important to recognize that in the area of insurance, which we're discussing today, that iCheck basically took the hardest cases, and those were the ones that were left after the reparations and compensation program started in 1953 that dealt with other insurance issues. And getting to that very difficult mechanism was the product of arduous negotiation that was undertaken by the government, and it included the Slave Labor Foundation, and iCheck was eventually joined to that. So I can certainly share your frustration that we're probably going to have some people with claims that were not resolved. But I do honestly believe that those are very, very few, and that the iCheck negotiation and the iCheck process was successful in answering those claims that had not been resolved in the earlier programs in the 50s, 60s, and 70s.
If I may continue, Madam Chair?
Yes, you may, for one more minute.
I appreciate the progress made by the iCheck process, and it was important. It was extremely helpful. It's laudatory. But to say that because there was progress made with some, that others can be denied is not really an acceptable argument. I don't understand how our president would veto this bill. Those of us who are on both this committee and on the International Relations Committee, some of us have a hard time understanding how this would be disruptive to our relations with Germany. Painful, yes, but not disruptive. There are too many other things at stake, and the people, if I had to name a country that was more anti-Nazi than any other country in the world today, it would be Germany, because they know what the Nazis did. This is not about anything other than greed. Greed is the issue to the questions that my friend Mr. Wexler and Ms. Ross-Leighton and others on this committee have raised. Why would somebody object to publishing the list? I mean, a lot of people are the heirs to things that are owed to them that don't know that their uncle or great-grandmother or grandmother or father had a policy unless they see it written down somewhere. This is about greed. This is about denial. This is another aspect of Holocaust denial. Not that the Holocaust took place, but that people paid for policies, and because of greed, as a result of the Holocaust, have had no way of knowing policies existed, assets were in place, that they were entitled. That's the answer to why not. It's greed.
Thank you very much, Mr. Green, for 5 minutes. Somebody gave me a list. You next, Mr. Scott. Thank you. Mr. Scott for 5 minutes.
Thank you very much, Mr. Chairman. This is a fascinating hearing, dealing with one of the epic parts of our history, world history. I think it's important to recall at this point a correspondence between Heydrich and his superior at the time, Himmler, just prior to Heydrich being assassinated in Prague. And that was, in that communications, Heydrich, who was the henchman, the architect of this for Himmler, said this, that it is not just the human worth that comes from this Holocaust or final solution. It is the wealth, it is the economic, and this is illustrated right down to the very taking of Jewish people's teeth during the Holocaust. So we're dealing with a monstrous situation here. Now, I want to ask about Bad Arolsen. I believe I'm pronouncing that right. Can you tell me about Bad Arolsen, either of you?
Thank you, Congressman. I'd be happy to talk about Bad Arolsen a little bit. When the Western Allies were storming into Europe at the end of the Second World War, they began finding, in addition to these horrific death camps and other places of mass murder, a lot of documentation and files that dealt with this issue. They were kept in the individual occupation zones for a while, and then in the early 50s, there was an agreement among the Western Allies that we needed to put all this in one place and find a way to help families use it for family reunification purposes primarily. There are three major groups of files at Bad Arolsen. One which is called the detention records, which is largely, well, it can be characterized by any contact with any of the police organizations, not the Gestapo, the Kripo, and also deportations to concentration camps. It covers the whole apparatus of the death machine, shall we say.
Let me ask, I only have a few minutes to follow this, but in addition to all of that, is it not true that also within Bad Arolsen there has been revealed evidence of corporate complicity, unrevealed insurance company involvement, pervasive IBM punch cards among the papers in the secret Bad Arolsen repository, and that this has reignited the grassroots survivors campaign to recover their rightful Nazi-era insurance claims against this huge Italian company, an insurance company, Generali. And is there evidence of Generali's complicity in this?
Congressman, I've been asking questions like that of the archivists who know the Bad Arolsen collections best on both sides of the Atlantic for over a year now. And I'm told that there is no systematic archive relating to insurance. I think it's possible, and in fact, the case I talked about, the Gestapo document we received just recently, we will occasionally find traces of insurance-related information that comes out. But at this point, what's in Bad Arolsen, in addition to the detention records, are slave labor and forced labor records, and then finally the displaced persons records. And in those, it's possible that there will be some occasionally appearing document that deals with insurance, but that no one who knows the collection well has been able to identify anything that would systematically reveal life insurance documents. There are some documents relating to medical and retirement insurance, which was another scam that the SS operated to bill companies and then use that money for their own purposes. But there's, when it comes to life insurance, casualty insurance, other than the random document, the random appearance of a document once in a while, there hasn't been anything yet. But it's something that we ask about constantly.
But I would think that this Bad Arolsen, I don't think has been examined thoroughly enough. I mean, if you look at it, they are the repository of nearly 18 million, as a matter of fact, 17.5 million Jews and non-Jews.
Yeah.
Wouldn't you think that this alone gives renewed justification for this legislation?
Well, Congressman, as I say, I don't think that the collection at Bad Arolsen is going to be awfully useful for insurance recovery matters. It's just the nature of the files doesn't lend itself to that. There will be the occasional document that is helpful to a particular person, but it's not systemic.
But if they've got evidence of corporate...
Sorry, no, time's expired. Can't ask another question.
Oh, okay.
We're over time. Did you want to finish the answer? Have you finished?
Well, I think I've finished, Mr. Chairman. Thank you.
Mr. Green.
Thank you.
You have another panel, and so we're going to have to stick reasonably close to the time. Mr. Green.
Thank you, Mr. Chairman, and thank both of the members of the panel for appearing. Mr. Ambassador, you have indicated that there is nothing that will prohibit victims from suing. Is this correct?
Yes, sir, that's my understanding.
Let us please examine this statement, because in the United States we have a concept known as open courts, which literally means that anyone can sue anybody for anything at any time for any amount of money. It does not, however, mean that you will prevail. It literally means if you want to sue, you may. So to say that you may sue is not enough to give people a proper understanding of what will happen after the lawsuit has been filed. Is it a fair statement that the government would file pleadings indicating that there is a limitations problem?
Sir, our pleadings, generally speaking, have asked the court to dismiss on valid legal grounds.
Yes, sir.
Any valid legal grounds. I'm not aware, I'd be happy to check whether we have specifically cited in a particular case a specific reason, like the one you know.
Generally speaking, requests for dismissals that broad are not granted, because you have to be specific as to why. General legal grounds, then you're saying, Judge, you become my lawyer and determine what my legal rights are and my legal grounds are. So generally speaking, that would not be sufficient. And if you plead limitations, what you're in essence saying is this: the folk that we are suing, the companies that we're suing, that to some extent created the problem, now get to benefit from the problem that they've created. They put us in the position where we could not bring the action, and now they're saying it's too late for me to bring the action. That is, in and of itself, is an injustice. It appears to me, and by the way, I think honorable people can have honorable disagreements, and I perceive you to be an honorable person.
Thank you, sir.
But it appears to me that this really is about more than money. It is about due process. It is about a desire to have an opportunity to know for myself what happened. It is about the desire to have discovery, to find out for myself what is in the record, what's in the files. Has there been something secreted that someone, even my government, may know about and not tell me? That's what due process gives you when you go to court. The ability to have your day and to understand what happened to the life that has been so horribly interrupted and so dastardly dealt with. It's just about that. And people in this country seem to cherish that right to have a day in court. So I would say to you, as you make that comment, this is just about the comment that people have the right to sue. If you would, I think it leaves something terribly necessary missing when you don't explain that right doesn't necessarily mean that it'll be anything more than filing a lawsuit. Final comment, because my time is about up. There was nothing that prohibited the administration from working with Congress so that we could have, in the final analyses, an agreement that Congress was a part of, that the administration was a part of, and that would have brought in all of the victims so that they could be a part of it in some way. Because that's what's missing. I think people live in this world where it's not enough for things to be right, they must also look right. And it doesn't look right to victims to have someone decide their fate without their input. I think that we should do more to dialogue before we get to this point. I yield back the balance of my time, Mr. Chairman.
Either witnesses wish to respond?
No, I thank the Congressman
All right.
for responding.
The gentleman from Florida.
Thank you, Mr. Chairman, and let me start out by thanking Dr. Kurtz for his testimony and the fact that the National Archives is up to the task as long as Congress is up to the money, and I'm glad to hear that. Some quick questions for Ambassador Kennedy. Thank you very much for your testimony and representing the administration's position here. Now, my understanding is that $300 million in claims that have been paid out, roughly, represents about 15% of what the administration thought was the potential pool. Is that correct?
Well, the valuation, current market value of the policies involved is something that economists have been struggling with since the end of the Second World War. It's very, very hard to do. I would say that, for example, if you pick your point in time and you can make calculations. Now, whether those calculations have any bearing on what finally happens to people, if I can give you an example.
Well, I don't. You're using up some time. I mean, the point I'm just trying to make here is that I've seen estimates of $17 billion that you guys are saying is something significantly less. But whether it's the administration's estimate or what other folks are saying is the total amount, it's a small percentage paid off.
Well, I think if you look at iCheck as dealing with the most difficult cases that were not resolvable in other fora, iCheck dealt with those cases. There were considerable other fora starting in 1953 in Germany that dealt with insurance reparations.
Okay. Let me ask you a question. Do you know how much we spent on all the administrative costs to have iCheck operate for this period of time? How much money did we spend administering the program?
Well, the U.S. government was not the funder of iCheck. It
Understand.
was the German insurance companies, the German businesses, and the German government.
So the answer is you don't know how much was spent?
You'd have to ask iCheck, sir.
Okay. I mean, the numbers I've heard are anywhere upwards to $300 or $400 million. So, I mean, if that's the case, it seems to me that there was more money made working for iCheck than was given out to the Holocaust survivors.
Well, I think...
Next question, I understand. Next question I have for you, sir, is that you made an argument earlier that you thought that it was better to use diplomacy because diplomacy in this particular case would get a better result than by going to court. Do I understand that to be one of your main points?
Generally speaking, yes, sir.
So given Mr. Wexler's point that only 15% of the claims have been paid, does the administration consider diplomacy to be working?
Well, no amount of money that's recovered is ever going to make people whole for this horrific experience that they suffered losing their loved ones, the material depredations they suffered. We're not asserting that. I would just go back and
So you're saying diplomacy didn't work in this
No, I'm saying it does work, because iCheck dealt with those difficult cases that previous administrative processes had not been able to resolve.
Okay, now let me ask you a question. I don't think you were back there in 1998 when they put this together, so it puts you at a disadvantage, I understand. But, you know, given all of your experience as a diplomat and everything, you know, and I'm just new to Congress, so I'm just trying to figure this all out. But it would seem to me that if you had a crystal ball back in 1998, that if you only thought that 15% of these potential claims would get paid out, would we have entered into an agreement, in your estimation, to spend hundreds of millions of dollars to get such a small result back in 1998? Is that something that diplomats do and the administration, I think it was the Clinton administration, would have entered into if they thought that that was going to be the result here?
Well, the iCheck process was claims driven. People had to file a claim for there to be a payment. I don't think anyone at the beginning of the process knew exactly how many claimants there could be. They knew that there was a large number of people who were victims or caught up in the Holocaust and who held insurance policies. But it was the excellent research that iCheck did after the process started, once it was established, that got us the results we have today. And I'd also note that, as Chairman Eagleberger did in earlier testimony, that in every case, iCheck's estimates of what it would need were very much on the mark.
Well, all I could...
Last quick question.
Okay. The only point that I'm trying to make here is that common sense tells you that a 15% result doesn't make sense. And what your argument is that we entered into an agreement, okay, and that we should honor an agreement for a flawed process. It's clear to me that the iCheck process, did not deliver the result. And if it didn't deliver the result and it's not delivering the justice that these Holocaust survivors deserve, why would we then continue to want to support this failed policy? Why not do what's right for the Holocaust survivors and get these people paid?
Any response, Mr. Kennedy?
Thank you
Yes,
for your time.
I think the earlier compensation programs took care of probably the vast bulk of the unpaid insurance claims that were out there. So iCheck is dealing with what couldn't be handled easily without the research, without the very dedicated work that the staff at iCheck did. Thank you, sir.
The gentleman from Florida, Mr. Wexler. The gentleman from Missouri asked his questions yet? All right, well, let me go to the gentleman from Missouri first, then the gentleman from Florida.
Can't hear you.
Could you move to the next one? Perhaps that would be better, Mr. Clay, if you would.
Perhaps that's better. Thank you so much. And Ambassador, with ICHEIC having finished their process, what assurances do you have that companies will continue to process Holocaust-era claims? Have you gotten any word back from insurance entities that tell you we will continue this process until it's complete?
Thank you for that very important question. I'm in very frequent contact with insurance companies, with insurance associations in foreign countries, and we have received assurances, from the companies that participated in iCheck that they will continue to process claims with the relaxed standards of proof that are similar to the ones iCheck used.
Would you have a running tally of how many have come through since the end of '04 or since the corporation shut down?
The German Insurance Association groups, I believe, 77 companies. We have a letter from the association, a copy of a letter from the association that it sent to this committee saying that they will continue to use relaxed standards of proof. I have similar assurances from Generali, which has a very significant company archive in Trieste. We have received similar assurances from Austria, so I'd say yes, we do have the basis to be optimistic.
But no hard numbers of how many remain out there?
It's very difficult to estimate, Congressman. I will say that the German Insurance Association shared with me that between March 31st of last year and the 1st of December of last year, they had received a total of, I believe, 72 new claims, less than 10 a month.
I see. How, what kind of, for those claimants who have had their claims satisfied, what kind of reaction do you get from the Holocaust-era survivors or their families?
Well, I think those that affected a substantial recovery are happy they did. Those who received smaller payments that they considered insufficient are probably happy they got the money they did, but wish they'd gotten more. Normal human reactions.
How about you, Dr. Kurz? Any reaction to that? Or?
I think the only thing I would say, Congressman, that from the point of view of the National Archives, any access to records and any access to information related to the Holocaust or any of these other areas is extremely, we think, significant and important. And I think that's our emphasis always is on access.
Do you think it brings closure to this chapter for some of the survivors and their families?
To get these payments?
Yes.
I think it's partly partial closure. I think also from the point of view closure comes also from historical accountability. And that's why I said what I said about access, because the more this information is out and people really understand not only what happened, but the whole effort to try to rectify what happened, it really provides a closure, I think, in a broader sense.
Well, thank you. Thank you both for your responses. I yield back, Mr. Chair.
From Florida, Mr. Wexler.
Thank you again, Mr. Chairman. I just want to say at the outset, I did not file this legislation with Mrs. Ross-Langton to in any way minimize the achievements and the accomplishments of Ambassador Eisenstadt and Secretary Eagleberger, which have been extraordinary. I stand in admiration and respect for what they've done. But I filed this legislation because what we are presented with today is the ultimate injustice. Having proceeded through the I-check process, which has expired. And Ambassador Kennedy, I appreciate that you say that insurance companies have voluntarily agreed to participate, even though there's no appellate process, there's no auditing process. I appreciate that they have voluntarily agreed to continue in some respects. But the process has expired. And we are presented with the ultimate injustice because what we have is a situation where using the administration's estimates and the estimates of the insurance companies, roughly 85% of the assets, the value of the assets of insurance policies from the Holocaust era remain unpaid. So the question is, do we let it lie? That's it, game over? Or does this Congress participate in a remedy which allows yet one last chance? This is it, one last chance. This legislation is the last chance for those survivors who have not received an equitable result to get it. And what the position of the administration is no, they will not get it. What the position of the opponents of the bill is is that no, the Holocaust survivors are done. They will not get their last chance. Now, what's the inequity? The inequity is because the victims of the Holocaust do not have their records. They burned. They were exterminated. They're in ravines. They don't have records. We talked about Bad Arson. Yeah, there may or may not be something in Bad Arson, but there's one place where there's records. The insurance companies have the records. And yet the insurance companies are not mandated. They have not provided all the records so that they can be viewed by everyone. If the insurance companies would provide the records, this issue would be largely over. But they haven't provided the records. So the next question is, why has the United States government put itself in a position of protecting insurance companies who refuse to disclose records from the Holocaust era? And with all due respect to a few of the leaders in the American Jewish community who have called me and said, Wexler, you're upsetting the apple cart, stop doing it, they too should ask themselves, how is it that they can sleep at night? When they know that the effort here is simply to provide that insurance companies should disclose their efforts to give people then the reasonable opportunity in federal court. Let's see, Ambassador Kennedy, if we can agree on certain facts. I think we agree that 90,000 claims were made in the I-check process, correct?
That would be approximately right, yes, sir.
Approximately 40,000, 43,000 of those 90,000 claims received or rejected outright. Correct?
You'd have to ask I-check about their process.
That's what their records indicate. 43,000 of the 90,000 were rejected outright. What their records indicate, maybe you can concur, is that 34,000 people received a humanitarian award of $1,000. Would you agree? So that's 77,000 of the 90,000. The remaining 13,000 received an average of $16,000 in compensation.
I believe that's also right.
That's it. That's it. 6 million people died in the Holocaust. 13,000 people have received compensation of more than a humanitarian token payment. That's the process we're defending here. That's the process that we're saying prohibits American citizens from going into court and having to fight their own government to get past the first, I'm here to make a claim. And I think it was Mr. Green and Mr. Cleaver who both brought out extraordinary points, which is it's a bit duplicitous to say we're not stopping people from suing. You're right, you can't stop them from suing. What the administration is saying, the moment you get into court, the full arm of the American government's going to say, we underwrote your ability to sue because we made an agreement with Germany, we made an agreement with other countries. Could we also agree that all of the companies that hold insurance, Holocaust-era insurance policies, have not been before the I-check process? And their subsidiaries, have they all been before that process?
I think all of the companies that probably were involved in European insurance markets or their successors, because many of these companies existed, the vast majority took part in the I-check process.
Vast majority. So there are some insurance companies and or their subsidiaries who have not participated.
I'd be happy to try and get a list for you, sir, but I would assert that basically they participated.
Okay, well, there's a legitimate difference of opinion then, because
finish up.
Because there are claims, I think legitimate, credible ones, that there are insurance companies and or their subsidiaries who have not participated, but they too now are benefiting from this legal peace argument, which is then even a double, compounded legal inequity.
Well, the legal peace argument applies primarily to Germany and Austria. Those are the two countries with which these agreements were negotiated.
Thank you. Thank you, Mr. Chairman.
I thank the witnesses, and we will hear the next panel. Quickly here, this is not complicated. I need the room cleared. We've got another hearing coming up, so please let's move quickly. Let's get everybody seated quickly. Let's not block the aisles there. Please, would the witnesses please take their seats? I want to get this thing started. Thank you. We need everybody to sit down. We're going to begin in a minute. Let me just say that everyone will have whatever material he or she wants submitted to the record. There will be no need to ask. We will grant by unanimous consent, to which there is no objection, the right for everybody to submit. I would also make a suggestion. We will consider ourselves thanked in advance. We probably save time. We'll get rid of 5 thank yous. And we know it's in the bill, so don't summarize it. Tell us why you think we should or shouldn't pass it, or we should change it. And we will begin with a constituent who has been a great source of advice and inspiration on this issue to me, a constituent of mine. We've changed order a little bit. Mr. Arbeiter is president of the American Association of Jewish Holocaust Survivors of Greater Boston. Mr. Arbeiter.
Thank you very much, Mr. Chairman, members of the committee. My name is Israel Arbeiter. I have lived in Newton, Massachusetts since 1970. I retired from my business in 1995, but have remained extremely active, especially in affairs of Holocaust survivors, including as a speaker in public schools, representative of survivors of several community organizations in the Boston area, and as president of the Jewish Holocaust Survivors of Greater Boston, a position I was first elected to in 1950, and I have been president of all but 8 years of this organization. I want to extend my utmost gratitude to Chairman Barney Frank, our own elected member to Congress, and a real champion of rights to everyone. Mr. Chairman, the survivors of our community regard you as a great friend and consistent advocacy on our behalf. And with your permission, Mr. Chairman, I would like to express my most sincere thanks to members of your staff for assisting and helping me to come here, especially Tom Glessick and Garrett Ross. I appear here today with very mixed feelings. On the one hand, I appreciate the opportunity to address this committee to urge the immediate passage of H.R. 1746, the Holocaust Insurance Accountability Act of 2007. On the other hand, I'm very distressed and even angered that 10 years after this committee first held a hearing in 1998 under Representative Jim Leach on Holocaust survivors' insurance claims, and 7 years after I first testified in Congress in 2001, the insurance industry has managed to escape having to fully account for its handling of our family policies, and has retained so many billions that we survivors should have received decades ago. Today, in 2008, there is no more time to talk. If Congress wants to do the right thing, passage of this insurance imperative with no more delays. The legislation would restore the basic rights of survivors. It isn't asking very much, really. Is it too much for Holocaust survivors to have the right to access to American courts, to sue insurance companies who cheated our families out of insurance proceeds? Is it too much for Holocaust survivors to make decisions for themselves about their property rights? Is it too much to require insurance companies who want to do business in the United States to disgorge information about its customers and give a complete accounting of its conduct during and after the Holocaust? I don't think so. I don't think it's asking too much to have the same rights as any other American citizen to hold insurers accountable. The survivors I represent and those I'm in contact with every day are confused and frustrated that Congress will stand by and allow the status quo to prevail. I was born in Plock, Poland, one of 5 sons of Yitzhak and Hagara Arbeiter. My father was self-employed as a costume tailor and had 2 employees and apprentices. He made a comfortable living. In order to protect his family in case that something were happen to him, my father purchased life insurance. Every week, an agent from the insurance company would call up on our house and collect the premiums. He wrote the date and amount in a booklet that was given to my father for that very purpose. I remember distinctly when my siblings and I asked my father why this man was coming every week to collect money. We were told that payment was for your future. Unfortunately, our future was anything but secure. In September 1939, World War II broke out and Nazi Germany occupied Poland. On February 26, 1941, in the middle of the night, following the orders of SS stormtroopers, we were ordered out of our homes and required to leave everything behind, including the life insurance policies, paperwork, and booklet in which the agents of the insurance company recorded my father's payments. From there, we were taken to concentration camps. My parents and my younger brother were later guests in Treblinka. 2 of my brothers and I spent the next 4 years in various concentration camps, including Auschwitz. By some miracle, the war ended and I was liberated. After the war, I attempted to pursue my father's insurance policy. I tried to find out whether it could be cashed in since my father had died in the Holocaust. However, my efforts were unsuccessful. When ICHEC was created in 1998, Holocaust survivors and family members were promised a decent, thorough, open process to recover a fair value from these insurers for their massive theft. Instead, we have been victimized again by a commission process which has operated without any public accountability under Swiss law, far from the praying eyes of the United States legal system. Amazingly, it was populated by the companies who had managed to hold on to our money for 5 decades. This idea was an abomination because companies were represented, but the survivors did not ask federal officials, insurance commissioners, or anyone else to negotiate for us. Why, of all the people, should the Holocaust survivors be the only ones whose property rights would be negotiated by others? In early 2007, after 9 years, ICHEC closed its doors, and the results are terrible. It paid less than 3% of the amount of the insurance owned by European Jews in 1938. now conservatively estimated to be worth $17 billion. Those of us who personally experienced I-check inefficiency and arrogant behavior were certainly not surprised at this awful result. My experience is typical and shows why H.R. 1746 is so important. In the fall of the year 2000, I learned that the creation of I-check, I applied for a claim form, filled it out, and sent it in. I soon received a letter.
Mr. Arbiter, we're going to need you to move toward a close.
I soon received a letter with the claim number 00067,890, which stated that all member companies will investigate my claim and report their findings within 90 days. A year after I filed, I had heard nothing. In 2001, I was asked by Congressman Henry Waxman to testify before the U.S. House of Representatives. I explained about my family history, my I-check application, and the Commission's failure to even follow on its rules. Time, we all agree, was of utmost importance. I listened to I-check Chairman Lawrence Egerberger, government officials, and other members of I-check who promised quick action, a fair process where rules are enforced, where everyone gets a fair share. We were told to be patient and that the system was new and would improve. Congress chose not to take any action in 2001 to give I-check a chance to work. Ultimately, in 2003, I found myself testing.
We're going to have to get to a conclusion on the bill. We are running late.
Okay. Some say that we should accept what I-check gave us because there was a deal to limit our rights to whatever I-check decided. This is simply not acceptable. Ladies and gentlemen, no survivor I know asked anyone else to make any deals about our insurance policy, and no survivors I know were asked if he or she agreed to any such deals. How dare anybody presume to deny the history I am certain about because I lived it? I know my father had insurance, but whatever deal was made by I-check failed to produce the fact, and I know that happened. So it is not disrespectful and respect anyone involved in I-check to say, I'm entitled to the truth, I'm entitled as a Holocaust survivor to any information that these companies have or that any other company has relevant to our past. Now there is no more time to deny me the history, nor the histories of thousands of families. I will finish at this, and I thank very much, Mr. Chairman.
Thank you, and the entire statement will be in the record. Mr. Eisenstein, we'll give you some extra time here.
I have an amended statement that I'd like for the record.
Yeah, the record's open for anything anybody wants to put in.
In my capacity as Special Representative of the President for Holocaust issues during the Clinton administration.
There are going to be a series of votes. We will finish Mr. Eisenstein's testimony. We will break for a vote. There are 4 votes. We may be gone for the better part of an hour. I'll ask the indulgence of the witnesses. We will come right back. Mr. Eisenstein, please go ahead.
I negotiated agreements with the German, Swiss, Austrian, French, and other European governments, resulting in payments of more than $8 billion in compensation to 1.5 million Holocaust survivors, their heirs and heirs of those who did not survive, including Jews and non-Jews, for slave labor, real estate, insurance claims, and art claims. I testified time and again before this committee and others on these agreements, including the legal piece that was part and parcel of it, and got bipartisan support. None of the $8 billion would have been paid or would have been possible without, in return, providing legal peace to the companies who paid it. These agreements were reached not just on a bilateral basis between the U.S. government and the governments of these other countries. They were done in a complex set of negotiations with private sector representatives and corporations abroad, and with the plaintiffs' attorneys, class action lawyers who brought the bulk of these suits, and with the World Jewish Congress, and with the Jewish Claims Conference, and in full recognition by the Congress, this committee, this chairman being ranking member, and with the Chairman Leach. The bill is currently drafted, threatens the integrity of the U.S. government's longstanding policy of resolving Holocaust-era claims through negotiation and not litigation. And I want to explain why that was our principle. The reason was that we wanted to have flexible rules of evidence. We wanted to have ICHEC, which was created by the insurance regulators, do the research, not lawyers, for the claimants. We wanted to have low burdens of proof, not the high burdens of proof that would exist in courts. The ICHEC process emerged from the impetus provided by insurance regulators in a number of states. In the spring of 1998, those commissioners and Holocaust survivor organizations invited the administration to support an international commission to resolve unpaid Holocaust-era claims and asked us to use our diplomatic efforts with European governments and companies to bring them into the process. We agreed. ICHEC was created, and the administration had an observer on ICHEC. We were not full members because it was a state-led process. Our support for ICHEC was premised on our interest in obtaining justice quickly. We knew that there was a time window, that litigation would be costly, uncertain, subject to all sorts of defenses, statute of limitations, post-war agreements, rules of evidence, and that this would consign Holocaust survivors to an endless and fruitless search for justice. And so what we did, whether it was slave laborers, people who had their property taken, people whose art was stolen, is to adopt administrative processes that could move quickly in the lifetime of these people, and that's what the ICHEC process was all about. It was done, by the way, also not only with the participation, all these negotiations, with Jewish organizations and Holocaust organizations, it was done with a representative of the State of Israel and with the Prime Minister of Israel being directly involved and informed of the negotiations. We had to involve, and perhaps the most difficult part of the process was the insurance issue, because insurance was regulated at the state level, and yet we had to merge our broader negotiations with Germany over slave labor and other issues with this issue. We felt that to ensure the inclusion of the broadest possible number of companies and countries, that state insurance regulators had influence only over those European insurers who could be subject to the jurisdiction of a U.S. court. And that meant only those doing substantial amounts of business here. We wanted a broader universe of insurers involved. And therefore, the ICHEC process allowed us to get insurance companies engaged in paying into this process who were not subject and wouldn't today be subject to the jurisdiction of these courts. We took a number of steps to support the ICHEC process. I testified in 1999 before this very committee, saying we continue to believe ICHEC is the best vehicle for resolving Holocaust-era claims. We reiterated that numerous times, and I wrote a letter to Eagleberger as chairman of ICHEC, stating that it was the foreign policy of the United States that ICHEC should be recognized as the exclusive remedy for resolving all insurance claims relating to the Nazi era, because courts were not a satisfactory, timely, and appropriate way to do it. Now, it's very important to understand what was done and what wasn't done in the negotiation with the Germans. We created a German foundation funded with 10 billion Deutschmarks, half by the German government, half by the private companies. The private companies included thousands of German companies, including insurance companies. The insurance piece was the most difficult piece to negotiate because the German insurers, led by Allianz, said that they would not contribute to our overall 10 billion Deutschmark pot unless they, along with all other German companies, including the Daimlers and the Siemens and others who were slave labor employers, got their legal piece. Now, what did legal piece involve? This is very important to understand. We had this 10 billion Deutschmark. We had to divide that 10 billion Deutschmarks between slave laborers and forced laborers, who got 8.1 billion. A future fund for tolerance programs got $700 million. More went to property, and we agreed after very difficult negotiations to pass through to iCheck 550 million Deutschmarks to iCheck for them to administer. But the condition of that was that Allianz and the German insurance companies, as the other German companies, the slave labor employers, needed to have legal peace. What did legal peace involve? They demanded initially a piece of legislation from Congress to cut off the rights of people to sue. We said that's not possible. They wanted an executive agreement that would cut off the rights of people to sue. We said that was not possible. What we did agree to was a statement of interest to say that it was in the national security interest of the United States that the cases be dismissed in return for the payment of 10 billion Deutschmarks. And that statement of interest simply said it was in the interest of the United States, the U.S. government, with the full understanding of the Congress, to promote that dismissal if there were valid legal grounds found by a court to dismiss the case. That was the single most contentious part of the negotiation. They said, well, that leaves a huge loophole. The courts have to find a valid legal ground for dismissal. And we said, that's exactly right. That's the most we can give, and that's what legal peace is going to mean in return for your 10 billion Deutschmarks. And that's what ended up happening. Now,
you need to wind it up.
I'll wind it up. Here's what I would suggest. I have particular concerns about the access to court issues because it cuts directly against the understanding that we reached after painful, long, difficult negotiations with these companies. It would totally vitiate the understanding that we reached in broad daylight with survivor groups.
We've got the point, but we do have to finish.
Part, there is a part to this legislation on the registry I want to talk to. I am concerned about the fact that people may not know and may not be paid for their policies. And here's what I would suggest. Instead of a registry which runs against certain privacy rules in Europe, I would suggest the following: that Congress pass in legislation a mandated requirement that all companies doing business in the United States submit periodic reports of their post-iCheck claims processing to the Congress and to an appropriate office of the Department of State, stating the number of claims submitted, the number granted, the reasons for refusal, the amount offered in compensation, to vindicate the public's interest in ensuring that companies live up to their commitments while still respecting our agreement and the privacy rules of European companies. They should do so according to the rules submitted by iCheck, the loose rules. I would go a step further and suggest that all potential claimants be told that they can file claims through the German Insurance Association, GDV, and that insurance association will distribute those claims to the appropriate German companies. And those companies would be obligated to search their files to see if there was a match, and then to report on an annual basis to the Congress and to the State Department on their results. This, to me, would be a more appropriate way of dealing with it than vitiating agreements that were long reach.
We're over time. We have a vote. So we will recess and come back when we're through voting.
Mr. Chairman, may I just ask, I'm supposed to be, I understand. How long do you anticipate we should?
40 minutes will be, it's going to be about 40 minutes or 4 votes. If you have to leave, we understand it.